All right, let's get going then. Welcome everyone. Thank you very much for joining this, which is a series of webinars from the employment team at King's Chambers. We're trying to do one every couple of months or so. They are uploaded to YouTube, so if any of you have missed any that you saw being advertised but were hoping to attend, you can find them there. Ben Williams did a disability discrimination masterclass quite recently, which has been uploaded. That's definitely a tricky area which people are often interested in looking at. So do have a look on YouTube if you want to. Doubt anybody will be rewatching this, but you can find it there if you have to leave early. Looks from the attendee list. I know quite a lot of you. Some of you I don't. So for those who don't know, I'm Sam Proffitt barrister and one of an ever-increasing breed of former employment solicitors who have made the transition to the bar. I more or less exclusively practice in employment law, and I did as a solicitor too. We're going to be talking today, or I'm going to be talking today, about the changes at the Employment Appeal Tribunal arising from the new EAT rules and practice direction, which have very recently come into force. Please do feel free to submit questions in the chat. If I see them, I will endeavour to answer them as we go along, and hopefully we'll have some time at the end as well. So what's occurring? Why are we here? So the statutory EAT rules have been in place since December 1993, and this is, by my count, the 10th statutory instrument updating them. But any of you who have dealt with appeals know in reality the useful document is and has always been the practice direction, which is non-statutory but sits alongside the rules. That was most recently amended slightly in December 2018. I put an asterisk there because it was also technically amended in 2020, but that was purely to address the issues which arose from COVID, virtual hearings and so on. The actual practice direction itself hasn't had a significant revamp for a long time. So what EAT President Jenny Eadie did earlier this year was to send out a consultation paper about proposed new rules and practice direction. The consultation paper didn't have a draft, but it did set out very clearly what the ideas were, and it asked for comments on them. So if you are interested in reading around where we have been and why things are changing, it is still a useful document because it explains the difficulties and frustrations, they're palpable frustrations in the wording, which the EAT has had with how appeals have been run, and therefore the purpose of the changes that it is implementing. So I put a link in there to the consultation paper. So if you want to have a look at it, you can view it when you get the slides, which will be sent out after the webinar. Myself and Laura Gould, who many of you will know is also in the employment team here, submitted a response to that consultation. And of course, like all good consultation paper responses, it looks like everything we said was ignored, and they did exactly what they already said they were going to do anyway. We're not at all salty about that, obviously. But what I think is clear, or was clear from the narrative of that consultation paper, is that there were a couple of key themes as to the purpose of the changes. Firstly, to streamline the process, and secondly, to avoid technical problems and strikeouts which arise from technical problems. It is clear that the EAT wants to deal with appeals on their merits and get away from appeals being disposed of purely because somebody has made some sort of technical error. It is also clear that the EAT wants to make its own job easier and smoother in terms of dealing with those EAT appeals. Those things reflect the reality that a lot of people still represent themselves in appeals, complex as it is. And I think to some extent mirrors how the higher courts have dealt with the employment tribunal process generally, thinking, for example, recent authorities from the Court of Appeal regarding making technical errors with ACAS early conciliation, for example, and how that should lead to a strike out or shouldn't in most cases, or where somebody's claim or defence has been struck out due to errors on the part of their lawyers, which also has been substantially relaxed through Court of Appeal guidance. I'm going to come back to that and to how it might apply in the EAT later. The new rules and practice direction came into force on the 30th of September 2023. There's always a question of transitional arrangements. Helpfully, paragraph 1.2.1 of the practice direction explains those transitional arrangements and quite simply confirms that it applies to any appeals started on or after 30th of September 2023, and for any appeals started before that, for any step which takes place after it. So in effect, if you have now got an ongoing appeal, anything coming up needs to be done in accordance with the new practice direction. So the points that I will cover in terms of the differences in the practice direction need to be actioned straight away. What you don't have to do is go back and change anything for a direction that's already been done. Now, what I don't know, because I don't see that side of things anymore being at the bar, but some of you may well know, if you have an ongoing appeal, is whether the EAT has written to parties to say there is a new practice direction. It would certainly be a good idea, because whilst you might expect employment lawyers to have seen some sort of legal updates, a bit like this one about it, you can't imagine why a litigant in person would see that. And the initial documentation about the appeal, of course, would have pointed them to the old practice direction. I imagine that there will be, in any event, a good degree of leeway over the next little while, particularly for litigants in person. And in reality, a failure to comply with the practice direction, old or new, rarely has any teeth other than the ire of the judge, which ends up with a rubbish authorities bundle or whatever it may be. But I think there may well, and I'll come on to this, there may well be more actioning of those teeth, given how much emphasis there has been on reading and implementing the practice direction. I've put links to the new rules and the new practice direction in the slide there. As with the old regime, I'm not sure there is much value in looking at the new rules, which are in any event only a statutory instrument. Everything is reflected in the new practice direction anyway. But if there is one takeaway from today, it has got to be to read and use the practice direction whenever doing anything with an appeal. It is a very accessible, easy to read and understand document. And although it has increased from 33 pages to 80 pages, that is not because it is more complex. It is because everything is explained in much more detail. It is also the sort of document, I think, where you might only need to look at one or two pages of it at a time, purely about the bit of the appeal process that you're dealing with. And there's also, as with the old one, there's quite useful headings, so you can quite quickly go to the bit that you're dealing with, look at the practice direction and action it. Useful bits in the chat. A couple of people have said that they haven't received any comms from the EAT in terms of ongoing appeals with the practice direction. What I imagine, therefore, is that everything that comes out now will refer to the new practice direction to make sure you use it. So on to the new rules. Well, as you can see from the slide, there isn't a great deal. there are only actually two changes to the rules themselves, one of which is Rule 3, dealing with documents instituting appeals, and one is Rule 37, dealing with time extensions for minor errors. The key point in Rule 3, or the only real point in Rule 3, is that the requirement to include the ET1 and ET3 has been removed. Now, it seems to me that that is eminently sensible. They are rarely read at the SIF stage. The original pleadings have often been amended or clarified through case management orders. And I can recall one example of an appeal where I did, where there were 10 ET1s and ET3s within one combined case. But it was a complete waste of time to include them all because it was an appeal about a case management decision for which the pleadings were basically irrelevant. So that requirement has been removed altogether. And it's important because one of the problems that arose and what this change, under the old rules, they weren't included. The appeal was not properly instituted. The problem with that is by the time anybody realizes and corrects it, they're then out of time. And it was very difficult to get a time extension under the old rules or something like that. So that directly feeds into the point I made earlier about the purpose of these changes and getting away from technical disposals of appeals. The other change under Rule 37 is a similar theme. It adds a new subclause 5 to expressly allow provision for a time extension where there has been a minor error in the documents which have been submitted. It is important that this is specifically in relation to minor errors with documents instituting an appeal. It is not an increased time extension provision. That remains the same, and I will come on to that. It is to be confirmed exactly how that minor error time extension will be applied, but the practice direction just repeats what the rule says. There is an emphasis on how quickly has the error been rectified. Is it in accordance with the overriding objective to give a time extension? What is the prejudice to the respondent? I suspect it will be applied quite generously, but we'll have to wait and see. The point for you there is if you notice or are told of that sort of error, rectify it immediately. And as I say, there is an emphasis on how quickly it was rectified where a minor error has been made. There are 7 listed changes to the schedules, to the rules, but they are largely just administrative. Things like including an email address as well as a telephone number. The main theme of the changes to the schedules is the words "you must read the practice direction" has been inserted 7 times. They now appear at the end of every schedule. And that perhaps gives you some insight as to how annoying the EAT find it when people, even lawyers, haven't read it. That point was specifically mentioned in the consultation. And that feeds back to my takeaway from today being, make sure you read it. It also repeats in the schedules that the parties must comply with the overriding objective and communicate with the other parties and the EAT in a respectful and appropriate manner. Again, this seems to be reflecting that the EAT is looking for a smooth, streamlined process and wants to avoid getting into satellite disputes about how the appeal has been conducted. So as you can see, very little material changes there. But I infer that the frequent references to how the appeals are conducted, the importance of reading the practice direction, that might mean the EAT is going to be more inclined to consider cost applications which, as you will know, are really extremely rare in the EAT. But again, we'll have to wait and see if that actually changes or not. So on to the meat of what has changed and how it is going to affect the appeals that you are dealing with. That is contained in the new practice direction. Perfectly decipherable is the best I could come up with as a change to the acronym. But the reason I think it is apt is because, as I mentioned earlier, it is clearly written deliberately in a way which is easy to read and understand, and therefore the EAT expects should be easy to implement. That is the main reason why it has gone from 33 pages to 80 pages. The annexes to it, with the new forms, are only 4 pages. So it effectively has 75 or so pages of explanatory guidance on how to pursue and prepare an appeal. And as far as I can tell, it covers everything that you might need to know, every step in the process, and how you go about completing that step in the way that EAT requires. What you'll also find is that it is structured in a way that allows you to simply go to that paragraph or paragraphs relevant to whatever you're dealing with, implement that bit, and ignore the rest for the time being. There is one slightly odd bit, I think, at the start of the practice direction, which is paragraph 1.4.1. And it says, not only must you, as the appellant, read sections 1 to 3 if you're a litigant in person, but if you are representing someone, you should ensure that your client does. Now, I can't see that there is any teeth in that direction. I very much doubt that any EAT judge is going to ask about it. And I also very much doubt that any solicitors are going to do it, because in reality, it's your job to distill things like this in an accessible way to your client and do it for them. But it says that you should do that, even if you are the representative, so take that guidance as you will. So what are some of the changes? So when you compare the practice directions side by side, there is obviously a loss of additional material. But what I've reflected in this slide is some of the things which I think are most notable. A lot of the updates are just more explanations of the existing directions. So whilst there isn't a clear change in how things are to be done, it will give you some better insight as to how to do it. So firstly, at the top there, basis of appeal, in some ways, the most useful is there is now a quite extensive explanation as to what is and is not a proper basis of appeal. The old practice direction simply said it needed to be an error of law without giving too much detail about that. That is, of course, pretty meaningless to a litigant in person. But it's also not that easy, I think, to conceptualize for lawyers often. But what the new practice direction does is to give a non-exhaustive list of potential appeal grounds. And what is also useful is that it explains what you need to do to show that error of law under that particular ground. So again, that is something to keep in mind when setting out on any appeal. That you need to try and think about things likely against one of those things which is or is not an error of law. The second point there, page limit on the grounds, is one of the things that was specifically mentioned in the consultation. And it clearly gets on the EAT's wick, is that very few people paid any attention to the 2-page limit, which was explained in the old practice direction. I put an asterisk there because it said 2 pages, except where there was an allegation of perversity or bias. The rationale being that you would need to explain those grounds in more factual detail. I've rarely seen an appeal which complies with that guidance. But one problem which we flagged in our response to the consultation was that it wasn't very clear whether it was 2 sides per appeal or 2 sides per ground of appeal. I've always taken the view that it is per ground because there is no reason, to my mind, that an appeal with 1 ground should have the same page limit as one with, say, 6 grounds. But as I say, there is no better clarity on that in terms of the new practice direction. What it says is that an appeal should normally be no more than 1 to 5 A4 pages in length. So it is still somewhat open to interpretation. There is no literal page limit on it, but a good appeal, and this is a theme I will come back to, is short, to the point, directly and clearly explaining the error of law, not going into the level of detail which it would in a skeleton argument. And again, the practice direction gives some good guidance as to what should be in it and what shouldn't be in it. Thirdly, I think one of the interesting procedural changes is that there are now a number of places in the practice direction which require a statement of truth. That didn't appear anywhere in the old practice direction. And you in particular need to use them where the grounds are on bias, procedural impropriety, or where you are appealing for an extension of time to present an ET3. That's a rare appeal because obviously you should just go to the ET first. These reflect that you are going to be asking the EAT to consider a factual account, a witness account of what has happened. What's the reason for the delay, or on what basis do you say that the judge was biased? Because obviously that's rarely going to appear in the judgment. So the EAT wants the party to have reflected on the importance of giving that account honestly. And there is some precise wording in the practice direction as to what the statement of truth should say. So again, look it up, make sure you include it, and you include it in the form that it sets out in the practice direction. Fourthly, there is a little bit of a difference in how the time limit extension process is explained in the practice direction, although I'm not sure that there is going to be any change in how it is exercised. So the old practice direction expressly referred to the case law on what a good excuse means and provided links to that case law. The new one doesn't do that, which I think, again, is in this theme of making it easy to understand and accessible. Litigants in person don't want to be referred to case law. It does say that time limits are strictly applied, but it uses the word exceptional circumstances, which don't appear in the old practice direction. But those of you who have dealt with this will know those words, exceptional circumstances, is the phraseology that is used in the authorities as to what is a and is not a good excuse. So, for example, mistaking the time limit is not a good excuse. The new practice direction also reflects the Rule 37 change, which I mentioned earlier, which is where there is a minor error in the documents submitted alongside for instituting an appeal. But as I say, that minor error discretion only relates to the appeal not being properly instituted due to not including the right documents. There is no change to the simple time limit that is applied and how it is applied in relation to Rule 37. Fifthly, a fairly key practical difference, I think, as to how you are going to do your bit as the solicitor preparing the appeal is how applications will be dealt with. Under the old practice direction, it simply said any application, set it out in writing. There was no guidance, no particular form as to how it should be submitted, what it should contain. And in my experience, what that resulted in is generally emails flying around to the registrar, some cogent, some not cogent, not always very clear whether or not an application was being made. It is now a much more prescriptive process. There is a form at the back of the practice direction called Annex 2, which you need to use for pretty much all applications. It sets out more or less all the different types of potential applications with tick boxes. So, for example, an application for an extension of time, postponing a hearing, doing a hearing remotely, if you want to rely on additional evidence, all of those things are set out. That last one, relying on additional evidence, also requires a witness statement, again with a statement of truth. What the practice direction says that if you don't use the form, there is no obligation on the EAT to consider an application, and it may not be actioned because they may just look at it as correspondence. It also says that if you make an application but don't use the form, the EAT may send it back to you asking you to complete it. So that process of getting the form, completing the form, submitting the form to the registrar really does need to form part of your standard practice as a solicitor dealing with appeals. The box giving the space to set out the application is quite small. Now, it doesn't say this, but I suspect that it will be permissible to complete the form and attach an application in writing, much as we do, for example, with the grounds of claim or grounds of resistance for an ET1 or ET3. But in any event, I think probably encourage you to be as brief and as clear as possible. So if it can fit within the box on the form, it's probably a good idea to do so. What the practice direction also has in relation to applications is a very long explanatory section about applications. There are 14 pages in section 8 about how to action applications under this form. Covers 15 different types of potential application. It explains what should be included, what will be a good or bad argument for them, and how the EAT will deal with it. That seems to me is really very useful. So again, if you are making an application, try to effectively lift what you are saying from the practice direction and make sure that you are covering those things. Because bear in mind that applications, interim applications like these, are generally going to be determined by a registrar, not by a judge. And registrars are going to know and use the practice direction to the letter. It's also important to note in relation to applications that there is a new, separate and specific application form for a Rule 310 hearing. So this is where you haven't got past the SIFT and you want to exercise your right to explain your appeal at a preliminary hearing. That is Annex 1. Again, the old system did not prescribe at all how you exercise your right to a Rule 310 hearing. My practice was simply to send a one-liner email saying the appellant exercises their right to a Rule 310 hearing, and you don't need to say anything more about it. Annex 1, the Rule 310 form, is really quite prescriptive as to why you are exercising your right to a Rule 310. So it asks you to confirm what aspects of the SIFT decision do you agree with, what aspects of the SIFT decision do you not agree with, and on what basis are you exercising that right? So the Rule 310 process now requires a bit more thought, but I'll come back to SIT a little bit later. Particularly in terms of bundles, again, something which really obviously gets on the EAT's wick is not complying with the practice direction on bundles. Very little has changed in terms of what goes into the core bundle, but it is set out slightly differently. One addition is that it refers to the scope for transcripts where they are available for bias or procedural impropriety appeals. In my experience, ET hearings are almost never recorded. Very few tribunals have the facility, and the ones that do don't tend to use it anyway. But it may be a reference to the increase in improved technology, and it may be that this becomes more frequent and used for appeals. It does also say transcript or part of a transcript. Now, whilst there's no page limit on a core bundle as opposed to a supplementary bundle, you can imagine that if there was a transcript of the whole hearing, it could be absolutely massive. So it's something to think about is if you are alleging bias or procedural impropriety, if you do happen to have a transcript, what do you actually need to include in there? And it's very unlikely, I would have thought, that you would need the whole transcript for it. In reality, 99 times out of 100, you're not going to have a transcript. But what you will have often is judges' comments under the Burns Part procedure. Something like that. Finally, one new thing altogether is what they are calling an ARO hearing. So that stands for an appeal from registrar's order hearing. Now, under the old practice direction, if you wanted to appeal a registrar decision, it went to a judge and they either determine it on the papers or at a full hearing. That includes an appeal where the registrar has refused an application for an extension of time. Now, it looks to me that there will not be a great deal of difference in practice as to how a judge goes about dealing with an ARO hearing. But the new practice direction does set out a process as to what an ARO hearing is, what needs to go in the bundle, and how it's going to be dealt with. It looks to me that there isn't going to be any real difference to an ARO hearing and a preliminary hearing. It's just set out under a different heading so that it is clear what sort of challenge it is, namely a registrar decision challenge. The only real difference I can see is that for an ARO hearing, it says that the other party is permitted to attend and make submissions. Whereas with a preliminary hearing, it says they may be permitted to attend and make submissions. Of course, whether you do or not depends on the circumstances, depends on whether you resist it, etc. So those are the things which it seemed to me stood out from the new practice direction. As I say, it is 80 pages, and it should be your Bible when dealing with an appeal. Always have it to hand, always have a look at it, and whatever you are doing. So a reminder then as to what hasn't changed. Firstly, and perhaps most importantly, the time limits themselves haven't changed. There remains an emphasis on a strict application of the rules and the need for a good excuse. The authorities which explain what a good excuse is and is not is effectively imported into the practice direction in that guidance. But my inference is that the discretion which the EAT may apply may be somewhat relaxed in order to give effect to the purpose of the new rules and practice directions regarding a streamlined, smoother, more just process. So that is somewhat TBC as well, but that is my inference and best guess. An important thing to remember is that deadlines in the EAT remain at 4 p.m. This wasn't mentioned in the consultation, but that was something that I thought might change. It is obviously a change to how deadlines are dealt with in the ET. And given that everything is dealt with by email nowadays, I'm not sure there's much to be gained by 4 p.m. Deadline, but it has stayed. So if any of you had an action to do today, unfortunately, you're out of time and it's going to be received tomorrow. The last point that I've raised on there, I mentioned earlier, is a question about liability of the lawyers. Now, this isn't covered in the practice direction, but I raise it because of the Court of Appeal decision you might have seen, FIPS and Prior Education Services. That came out a few months ago. And it addressed what happens where a lawyer makes a mistake and it causes their client's claim or defence to be struck out, or perhaps it's out of time. And the reason I raise it is that for many years, the ET and the EAT has applied what is often called the Deadman principle. And that is where you say, well, if it's the fault of the lawyers, if you've instructed skilled advisors and they mess up, then the client's remedy is against them, rather than the ET saying, okay, we'll reinstate the claim. That is called the alternative remedy argument. And in most cases, the suggestion is that, well, you can just go and sue under the professional indemnity insurance that they all have. That's been quite a successful argument for many years, and it's one that I've run many times. But the FIPS decision says that in practice, that is a typically unrealistic and unjust outcome for the individual. And what Lord Justice Bean said in that decision was that where the alternative remedy for suing for professional negligence is put forward against a factor of reconsideration of a decision, it should be treated with skepticism. So if, for example, a appeal is late, and it's late because of the lawyer, the flip side of the reconsideration argument may be, particularly if the person is represented, well, that's the lawyer's problem, that the individual can go and sue them. But Lord Justice Bean says that that sort of argument should be treated with skepticism. Now, it seemed to me that the logic of that should apply in the same way to mistakes made in the EAT as it does to the Employment Tribunal. So whilst there is nothing in this guidance which refers to that, it does seem to me that it's a practical point which we may find the EAT implementing arising from that recent Court of Appeal decision. That may well give you some comfort. I don't know, don't rely on it. It's just something that I think may well prove to be the case. So what does it all mean? So having regard to the new rules and practice direction and my experience dealing with appeals, these are some pointers which I hope will be helpful when pursuing an appeal. So first point is to keep it simple. So one of the points raised in the consultation paper, as I said, is how rarely people stuck to the 2-page limit. That's now a 1 to 5 page limit. The new guidance obviously doesn't clarify whether it's per ground or per appeal. But the point is there is a focus on ensuring that appeals are short, they are to the point, they shouldn't be littered with authority. It should really only take a few moments to understand why, on your case, the tribunal got the law wrong. The second point I suggest is that you avoid nitpicking. Those of you who have done a lot of appeals will know that counsel for the respondent, i.e. the other side, will almost always make the submission that the appeal grounds are based on an overly pernickety and impermissible reading of the Employment Tribunal's judgment first time around. So authorities like DPP and Greenberg, the point that is made there is that there is a presumption that the Employment Tribunal had the right things in mind, and it gets the benefit of the doubt. So the way this works in practice is that EAT judges frequently dismiss appeals where the ground relies substantially on a single line or a paragraph in a judgment, which might well be wrong. The reason being is that it is rare to find a judgment which doesn't have some factual mistake, or where there isn't some slightly odd logic, or where the law is sort of slightly misstated or something like that. You mustn't get hung up on those sorts of things. You've got to stand back and ensure that the judgment as a whole discloses an error of law which makes a difference, rather than just picking up on something and saying, well, that sentence is clearly wrong, and therefore I appeal. The next point I have raised is a question that I've seen from judges many times, and it's something for you to ask yourself, and that's, isn't this just a perversity ground? Perversity grounds, as you'll know, are notoriously hard to succeed with. They are rarely worth pursuing overtly. But I find a trap or an error which people often fall into is pursuing a ground under some other head. But when you read it and you think about it, it looks like, and the EAT judge will perceive it as, a pseudo-perversity ground. Now, personally, I think that EAT judges, the SIFT judges in particular, don't pay enough attention to perversity grounds. They are almost always dismissed out of hand because it is such a high hurdle. But the point that I'm making here is that unless you really are pursuing a perversity ground, and you're really confident that you can set out clearly why the decision was perverse, I suggest that you avoid appeals which look like an attack on the facts and are effectively a perversity ground, even where they are to some extent intertwined with the law, because the response is likely going to be waving away your appeal on the ground that it looks like perversity, it doesn't meet that high threshold, and therefore it's very difficult to get the judge to grapple with your substantive ground. The next point I say is don't be meeky. So that's a reference to appeals which say the judgment is not meek compliant, and that is to say a judgment where the reasons don't sufficiently show why you lost. And a bit like perversity, this is a ground which EATs really don't like. It is often similarly rejected along the lines that you're just not reading the judgment as a whole. And there is nothing in law which says that ET has to set out all of the relevant law or all of the parties' submissions and address them. In any event, if your appeal turns on it not being meek compliant, if that is the long and short of it, it is pretty much always going to go back to the same judge. And if it is just better reasons which are required, it's pretty unlikely that the decision is actually going to change. So query whether you will gain anything by pursuing it. In terms of the SIFT, we have probably all seen good appeals which don't get past the SIFT and ultimately went on to be successful on precisely the same grounds. The reality is the SIFT is often done by a deputy judge. It is a very high level review of the grounds, and a number of those SIFT judges are not employment specialists. One of the reasons that I think it is important to not nitpick with sentences in the judgment, to not pursue pseudo-perversity, is because SIFT judges are often going to wave away those grounds very easily if that's how they read it. The comments alongside the SIFT should make you think about it. But in my view, you shouldn't feel too disheartened about needing to get through a Rule 310, because it is very common indeed to not get through the SIFT, but then get through Rule 310. It is, however, in my view, worth reviewing your appeal grounds between the SIFT and the Rule 310, and considering dropping any grounds which seem weaker. That can be persuasive, in my experience, to a Rule 310 judge, that you are looking at things afresh, you are looking at things fairly, and you've decided not to pursue a weaker ground. As I have said, and the EAT has said, as I say, 7 times in the schedules to the new rules, follow the practice direction carefully. Very few people deal with appeals day in, day out. Very few people have the EAT rules and practice direction at their fingertips as they might do PET rules. So particularly given that the new practice direction is very clearly set out, very detailed, have it to hand and review the relevant bit every time you do something on an appeal. The EAT is a different animal to the Employment Tribunal, which we know the rules in the Employment Tribunal are in practice very relaxed. The practice direction is your friend, and if you follow it carefully, you are unlikely to make any material procedural mistakes. And as I say, my inference as to a way in which the practice direction might be implemented is potentially to use those cost rules in a way that the EAT hasn't typically done so in the past. The argument being, well, the practice direction is so clear and you have not followed it, and therefore there is unreasonable cost as a result. The final point that I raise is about disposal. The new practice direction makes clear that what the parties want by way of disposal needs to be included as part of the appeal itself. The old one said the same, but in my experience, that's often missed or not really thought out cogently. Frequently, the end of an EAT judgment is a discussion about disposal, and it is clear that the parties have not particularly thought about it or don't have a good argument for what they want. And it seems to me that that is a significant strategic error, because it is relatively rare to get a full rehearing before a new panel. The likelihood is, if you win, something is going to be remitted. And if you don't have confidence in the judge or the panel which has dealt with it, you risk a Pyrrhic victory of winning an appeal, getting it sent back to the same judge or panel, and ending up with a very similar outcome. So if it is the sort of case where it is always going to get remitted, and even if you win, the judge or the panel retains a wide discretion. So let's say whether to apply a percentage deduction on remedy for Polke or Contra or something. That, in my view, should give you pause as to whether you're really going to achieve anything by pursuing it. And I think it would be a good idea to really think about what are we actually going to achieve if we win this particular appeal. So that is my summary as to the new rules and the practice direction. Please post any comments or questions in the chat. Finally, you've all attended wanting to know about the new EAT procedure, but I suspect what is going to be much more important for most of you as employment lawyers is that today the Supreme Court has handed down its long-awaited decision in the Agnew case. And it does what I think most people were expecting, which is to overrule the Bear-Scotland case about a series of wages deductions being out of time if there was a break of 3 months. That was always difficult to understand. The Supreme Court has said that's not right, and whether or not there is a series of deductions is a question of fact. Where there's a common fault, for example, where holiday pay is consistently paid incorrectly, perhaps they're using the wrong pay scale or whatever, the fact of there being a 3-month gap is irrelevant. Now, of course, that is a much bigger topic. No doubt it will be covered by another of our webinars in due course. But I felt it would be remiss of me not to mention it, as I do think it represents a big jurisdictional change for that delightfully simple area of law, which you all enjoy so much, being holiday pay. So unless there are any more questions, it's 25 past 5. That will bring the webinar to an end. As I said, the slides will be sent out and the talk will be uploaded to YouTube in due course. Many thanks for attending. I hope you all have a wonderful evening.